welcome to Law Easy. My name is Marty Schenkman and joined by a friend, colleague, Jonathan Blotmacher. And we're going to talk about a really important topic that presents incredible planning opportunities, great flexibility, and while it's become much more common, I think it can be used to a far greater degree to really help lots of people with their trust planning establish different stuff that can be really useful to them. Bifurcation of trust functions. Please remember with all the Law Easy video clips that they're for educational purposes only. Jonathan, we can slice and dice the typical trustee function, which historically was one person, a trustee, into lots of different components: administrative general trustee, investment trustee, insurance trustee, and so on. And there's more. Can you comment on why that's so fascinating and so important?
Well, let me tell you how I came onto this, Marty. I once had the honor of doing some work for the estate of Langston Hughes, who was a great poet in the United States. And his will was admitted to probate in New York County. And he appointed a literary trustee because he wanted someone who would understand his works. I mean, again, he was a great poet. His works were worth a lot of money. He wanted them disposed of in a particular way. So he appointed a particular person who was knowledgeable in those areas to be the literary trustee. And the Surrogates Court of New York County accepted that. And it's happened since then as well. However, one of the real downsides, even assuming you can do it under state law, you can say Marty is going to be the investment trustee and Jonathan will be the guy who controls distributions, the distribution trustee. Well, it may be that I'm still liable for Marty's action as the investment trustee. In Alaska and perhaps other states, it's clear that if you are not charged with one of the trustee functions, you're not going to be liable if it's misused. So if I'm only the distribution trustee, Marty's the investment trustee, and Marty makes a mistake as an
Why
investment
can't you make
trustee,
the mistake?
well, I'll come back to that, Marty. It means that I won't be liable. But if you want to use this, you can put it in the instrument explicitly that, if you don't have the power of the function, you're not going to be liable for it. But again, in New York, there's an indication that that won't work. You would at least have to monitor. So Alaska has an explicit statute that expressly states that, and I also put it in my documents, and you want to really consider that. But think about some of the things you want. Let's just take something standard, an irrevocable life insurance trust. So your client comes in with the insurance salesperson and says, "I'm going to buy, $5 million of insurance. What should we do?" And you, as the lawyer, say, "You got to buy it through an irrevocable life insurance trust. That way, even if you die the next day, it won't be in your gross estate for tax purposes." Great idea. And the lawyer says, "Who do you want to be trustee?" And maybe the agent says, "Well, I really shouldn't be because I'm making a sale to the trust, and that could possibly be even an act of self-dealing. So how about you, Miss or Mrs. Attorney?" And you say, "Okay, I'll be the trustee. It's not much for me to do." But you may be liable. And believe me, after a while, it's going to be difficult to justify why you bought one particular policy or kept one particular policy as opposed to another. So one of the things you want to think about is having a separate insurance trustee. And I typically would put in a member of the family. Maybe you put in the spouse of the insured, because if he or she is also a beneficiary of the trust, they're probably not going to sue themselves. And I doubt if the kids will sue them either. And in fact, you could even say that if they bring suit, you're out as a beneficiary. And you want to have broad language about keeping the policy and not having to go back every month and look at it, because a lot of people in the life insurance industry come in and say, "We'll do as a study of what policies you have," and guess what? Every time they come up with something better.
Selling you something new.
So that's right. So you've got to think about it, but you can have several different areas. One thing is, suppose you want to trust in, say, South Dakota, but the family doesn't live there. How are you going to get South Dakota? Well, you'll appoint a trustee who lives or has an office in South Dakota as the administrative trustee. And Alaska, again, has a specific rule of what kind of powers you have to give a trustee so you're assured of having an Alaska trust. It's a fascinating topic, Marty, but again, you have it down: insurance trustee, art trustee, literary trustee, family business trustee. But you
That
also,
being, let me just interrupt. That is one of the most common uses I see. I'll name an investment trustee who will have authority for family business matters. And oftentimes we'll even bifurcate the investment trustee role and have an investment trustee responsible for marketable securities. And that may even be the institutional trustee, but somebody specific for the family business that knows the business to make business type decisions. And in a lot of cases, it won't be one person, but a committee of people. The bottom line is that by naming bifurcated trustee functions, it's a wonderful way to accomplish a myriad of different client goals. The biggest objection that I find from clients is to naming a corporate trustee is, well, I don't want them running my business. Don't name an investment trustee to do it. And the flexibility that you create gives the possibility for someone creating a trust structure, especially if they're doing more complex asset protection or tax planning, to name an institution so they get all the independence of an institution. It's very hard to argue an implied agreement with an institution. Institutions tend to keep records dramatically better than many family members, but yet something like insurance, where you don't want the cost of an insurance evaluation or perhaps the trustee saying to change the insurance, or a family business or artwork, you can really bifurcate so you can have multitudes of different assets held in a trust and minimize the cost and maximize the flexibility. It's a huge opportunity. And one of the points, I just want to get it in because I don't want to lose the opportunity to say it. Oftentimes, I think when advisors are creating more complex trust structures, they view that as something for the realm of the uber wealthy. These concepts, especially with document generation software where it's click, click with a button to add these functions, you can add really significant flexibility and accomplish lots of family goals with just adding these different functions. And in fact, one of the things that I suggested on the slide, if you're planning a trust and you don't think you need a separate insurance trustee today, maybe you just build it in. Then you don't have to go back and incur the cost or hassle of doing it later, should that become relevant. Jonathan, do you want to comment a little more about state law and document provisions to make this work?
Well, again, there are some states where I don't know that it really will work, where you can't exonerate the trustee or the person who's not given that particular type of title. Like if you have an art trustee. So you're saying, well, Marty will be the trustee in charge of art to determine when it will be sold, to whom it would be sold. That sounds great. But it may be that the other trustees are going to be liable if Marty screws up. That actually happened in a case in New York. So it's pretty scary, and I would suggest you make sure that state law will go ahead and respect these different functions by different people and not have cross liability with the others. And in fact, maybe you even have a tiebreaker. So if it turns out that both the investment trustee and, say, the art trustee or the family business trustee both should or maybe want to participate in a decision, well, you should have a mechanism to have a tiebreaker, someone who says it, or to allow each of them to delegate. So maybe the investment trustee says, even if I have power over this decision with respect to the business, I am going to delegate that over to the people who are the business investment trustees.
Excuse me. Let me emphasize where the comment Jonathan just made comes up frequently. Two areas, two issues. One, the trustee is going to make a loan to a child who's a beneficiary of the trust. Is that really a decision for the distribution trustee? Because even though it's not a distribution, it's a loan, who has authority over that? Is it really an investment? But if it's an investment decision, why would you, is it really an investment? Or are you really doing it to help a beneficiary? So loans become sort of a sticky wicket that you may want to expressly address who makes that decision. Second area is with respect to um, um, personal use property. And I know, Jonathan, you are or have been trustee with a trust owning lots of personal use property. Is that really an investment decision if the trust is going to own a house for the investment trustee or investment advisor, director? Or is that going to be a decision for a distributions person? Because a house is often an expense, not a real investment asset. So who makes those decisions?
Well,
So loans and personal use assets are things you do want to address. But again,
and,
if
and Indeed, Marty, I have owned tens of millions of dollars of homes, which I have allowed the beneficiaries to use for free or for payment of the expenses relating to the home. But I expressly put in my documents which trustee have that power to allow the beneficiary to use that home. So, do you want that to be part of the investment decision, or do you want it to be part of the distribution decision? You need to expressly state who has that power.
And it's very important when you have an institutional corporate professional trustee, which again is my default preference because it just makes every trust run better in my experience, and it's much safer from the standpoint of deflecting a tax or asset protection challenge when you have an independent professional trustee. But what you want to also do is make sure that you deal with these issues. But think of the flexibility you have. Many institutions, maybe even all institutional trustees, are not always comfortable with making some of the decisions on a loan to a family member or a purchase of a personal residence or artwork or other property. And especially if it's something like artwork, which is hard to monitor, they may be uncomfortable making that decision. So it's a wonderful opportunity to make the trust have the flexibility by naming a person responsible for that, yet keeping the benefits of an institutional trustee. And as Jonathan said earlier, using South Dakota as an example, cite us in a trust-friendly jurisdiction. Jonathan, we're pretty much out of time. Do you want to make any final comments on trustee bifurcation?
Well, Marty, it is not used as often as it should be. I
No.
think if you're dealing with any significant amount of property held in trust, you really ought to think about who ought to make the decisions, for example, on distributions to beneficiaries. Who should make the decisions on investments? That's a much better way to go forward. But make sure you're in a state which will allow it and not make all the trustees liable if a mistake is made by one of them.
Thank you for joining us. Jonathan, thank you for your insights. Just remember that all the video clips on Law Easy for educational purposes only, but trustee bifurcation is really a powerful tool and I think deserves a lot more discussion and a lot more trusts. Thank you.